Hi, I'm Officer Troy Nico with the Advanced Training Unit. The purpose of this training video is to provide you with some supplemental training from previous use of force training that was provided to you by the Advanced Training Unit. Some of the topics we're going to be discussing today include constitutional standard, case law, and department policy, show of force, unresisted handcuffing, distraction techniques, and neck holds. This training video is as a result of recent use of force training in which several training gaps were identified. These resulted from changes in course material that was being presented. Revised policy also became effective in the time since the delivery of the use of force training. The purpose of this training video is to specifically address those training gaps and review related policy in order to ensure consistency in training for all members of the department. As I mentioned before, the first topic we're going to be discussing today is constitutional standard, case law, and department policy. So, case law versus policy. Case law is utilized and discussed in training to illustrate how the courts analyze uses of force. It's critical that officers understand that APD's policy has established higher standards, more restrictive than the constitutional standard and case law precedent. This means that an officer's actions can be deemed constitutional when assessed utilizing the objective reasonableness test as established in Graham versus Connor, yet be in violation of department policy, which could result in discipline up to and including termination. So now, as I mentioned, let's look at some APD policy and how it can be more restrictive than case law. The first case we're going to be discussing is Plumhoff versus Rickard, shooting at a motor vehicle. We're not going to discuss this entire case. I'm sure we're all familiar with it. Let's look at some APD policy that's similar to this case. 1. Officers are prohibited from reaching into vehicles or intentionally placing themselves in the path of a vehicle, thereby creating a justification for the use of lethal force. 2. Officers shall make every effort to move out of the path of a moving vehicle to a position of cover. 3. Officers shall not discharge a firearm at or from a moving vehicle unless an occupant of the vehicle the officer is engaging is using lethal force other than the vehicle itself against the officer or another person. 4. If an officer faces an imminent threat from a moving vehicle that the subject is intentionally driving into the officer or others, the officer may use lethal force only if 1. The officer has no reasonable alternative, and 2. A reasonable officer would believe the lethal force will remove the danger the vehicle poses without creating additional risks to bystanders. Officers should consider whether the use of lethal force creates a danger to the public that outweighs the likely benefits of its use. Let's look at another case, Scott versus Henrik. This case discusses that officers are not required to use the least restrictive means. APD SOP 2-52-4E, minimum amount of force, states, A. When force is necessary and objectively reasonable, officers shall strive to use the minimum amount of force that is feasible within the available range of objectively reasonable force options. 1. Officers need not start at the lowest level of force in every situation. Prior to using a particular force option, officers should evaluate their objectively reasonable options and select an option anticipated to minimize the level of injury to the subject and the officer while achieving the arrest or lawful objective. 2. While utilizing a particular force option, officers should continually assess whether the opportunity exists for them to safely de-escalate their level of force while still achieving the arrest or lawful objectives. 3. Whether a particular use of force is the minimum amount of force necessary must be objectively judged from the perspective of a reasonable officer on scene, rather than from 20/20 hindsight. The objective determination of minimal must account for the fact that officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. Keeping this policy in mind, let's look at APD's definition for minimum amount of force necessary, as it is defined in APD Procedural Order 2-55-2T. It states, the lowest level of force necessary within the range of objectively reasonable force that is necessary to make an arrest or to achieve a lawful objective without increasing the risk to the officer or others. Just to reiterate, when thinking about use of force case law and APD policy, APD policy can and oftentimes is more restrictive than that case law. An example of that would be our pursuit policy, in which our policy is clearly more restrictive than the case law for pursuits. This training has covered several identified training gaps and critical issues. It is important that officers have a clear understanding of the APD use of force policy suite: 2-52, 2-53, 2-54, and 2-55. Possessing a knowledge and understanding of the use of force policy will not only assist officers in making good use of force decisions, but also ensure that their decisions are not only objectively reasonable, but also within policy. If you have any questions in reference to case law as it applies to APD policy, please contact me at the APD Academy, 343-5000.